It's already there, but just refresh or check your video quality. It's 3.
Yeah.
Look there. Refresh. I want to check your picture.
Keep it going.
Greetings to all the participants on the platforms and welcome to the maintenance webinar program being hosted by the Mpumalanga DP division. Thank you for taking this time to join and be a part of this webinar, and we are certain that at the end of this program you would have learned 1 or 2 new things and or received clarity on certain issues that you are uncertain about when it comes to maintenance. Knowing maintenance, it is a topic that is very serious, important, as well as also quite sensitive. It's a topic that affects children, it affects families, it affects marriages, and also finances. Today we will have discussions under certain topics, as well as looking at legislation which governs maintenance and also jurisdiction in which these matters can be heard. Maintenance is also a topic that has a lot of views that come to opposite ends, specifically in respect of it being favoring to a specific gender. However, today we will receive clarity on all of the above. It is important that as prosecutors we are equipped with such information, especially because as a prosecutor we are all maintenance officers, and we should at every point be in a position to deal with such matters. Before we proceed with the program today, though, we would like to first start with our acknowledgements. We would like to acknowledge our National Director of Public Prosecutions, Advocate Shamila Batoyi, the Deputy National Director of Public Prosecutions, Advocate Rodney Dukok, the Director of Public Prosecutions in the province of Mpumalanga, Advocate Kanyane, the media houses which are joining us on our platform. Thank you for taking this opportunity to do so. Your presence is very important because this is a way in which we are able to reach our communities and equip them with such information. We'd also like to acknowledge our Regional Communications Manager, Monica Nyuswa, as well as our 2 speakers for today, Advocate Krista du Plessis, as well as Advocate Mahati Makata. I will then proceed to start off with our introductions. I will introduce myself. I am Tobeka Pungula. I am a state advocate based in Mpumalanga in the Organized Crime Unit. Secondly, we have got Advocate Krista du Plessis. Advocate Krista du Plessis is a senior state advocate. She is also based in the DPP's office here at Mpumalanga in the soccer unit, being the Sexual Offences and Community Affairs. She is also the provincial manager for Mpumalanga Division and is in charge of all our Tutuzela care centers, of which we have 6 in the province, and she will then take us further through that. Advocate Krista du Plessis will cover the following topics today. She will give us the purpose of the day. She will give us the role of the NPA in respect of maintenance matters. She will also discuss with us what is maintenance and who is liable for maintenance. Then we will have Advocate Mohati Makata. Advocate Mohati Makata is also a senior maintenance provincial prosecutor in the soccer unit in Mpumalanga. And Advocate Mohata will cover the following topics. He will look at maintenance as it pertains or relates to divorce matters, customary marriages, formal and informal inquiries, civil and criminal remedies, as well as future maintenance. Thereafter, we will have our regional communications manager, Monica Nyuswa, who will then at the end of the program facilitate our question and answer session. Before we proceed with our program, we would like to lay down some house rules. Firstly, we humbly request that all participants remain muted throughout the program, as this will assist us to minimize any interferences as we proceed with the program. Secondly, we request that the cameras remain switched off. This will allow our speakers for them to show on the screens whatever presentations or anything that they need to showcase. We are also requesting that in respect of the questions and answers, as indicated, we will have such a session at the end of the program. However, if you do have a question as the program goes on, as the speakers are presenting, we request that you put your question in the chat box. We are humbly requesting that there be no interruptions or speaking or stopping the speakers while they are presenting. All questions that are in the chat box will then be dealt with at a later stage. We do anticipate at this stage that our program will last for a period of 2 hours. Your cooperation and your participation will be appreciated in that regard. We can therefore move on to our first speaker, Advocate Christa du Plessis.
Morning everyone. As indicated, I am Christa du Plessis. I am with the National Prosecuting Authority, and more specifically the section called SOCA unit within the NPA, as also indicated standing for the Sexual Offences and Community Affairs unit. In short, what will be our purpose for today? It is to educate the public about maintenance legislation, the processes to be followed, and the role of the NPA within the maintenance system. I thought it will just be fitting for us to start with a proverb that says, "When elephants fight, the grass suffers," which simply means that the weak gets hurt in conflict between the powerful. I first came across this proverb when I was reading a maintenance judgment, and I thought it's so fitting for us to be mindful always that when elephants fight, the grass suffers. In maintenance, this cannot be more true. If adults in divorce proceedings or in maintenance fight continuously, it is the children that at the end of the day suffers. We are currently busy with the 16 days of activism of no violence against women and children, and we cannot be more fitting for us during this period to also talk about maintenance. We already heard that maintenance is a very contentious issue. There is a lot of emotions often that go with maintenance when one deals with the maintenance in the courts, and it's important to be educated about your rights and your responsibilities when it comes to maintenance. I will start off with the role of the NPA in the maintenance system. My colleague here, Advocate Kungula, said to you already, all prosecutors are maintenance officers, and the Act provides for that. Section 4, subsection 1 of the Act says that every prosecutor is also a maintenance officer, and as such must ensure that the services are provided in line with the directives that are issued in terms of Section 4, subsection 1b of the Maintenance Act. These functions include, but is not limited, to ensure that all prosecutors deal with maintenance matters in a fair, objective and sensitive manner, ensure that all relevant information is obtained and all the relevant information is placed before the courts, to ensure and to assist the court to arrive at the just and equitable maintenance orders. Prosecutors must be mindful of Part 26 of the National Prosecuting Authority policies to know exactly what is required of them when they deal with maintenance matters. As the NPA and as prosecutors, we are not alone when we deal with maintenance matters. We have other stakeholders such as the Department of Justice, where we have our maintenance officers employed and appointed by the Department of Justice in dealing with maintenance matters. It's just important for all of us, when we deal with it, to know our part and our responsibilities in dealing with it. The maintenance section within SOCA unit focus on providing maintenance services. The maintenance section comprises of senior maintenance prosecutors stationed at the NPA regional offices and head office to implement the SOCA maintenance mandate. Advocate Makata next to me is the senior maintenance prosecutor for Mpumalanga, and also responsible to ensure that we educate the public on the legislation surrounding maintenance, as well as all the procedures to be followed. It's also part of his role is to educate and train prosecutors to ensure that they are equipped to deal with all maintenance matters. So we can ask ourselves then, what is maintenance? Maintenance is simply the duty to support. Therefore, maintenance is the amount of money that a person has to pay towards another person based on a legal duty to support that person. Maintenance includes for the provision of accommodation, education, food, clothing, and medical care. The concept of maintenance is protected while there's a common law, firstly duty to support. But because we have such difficulties, the legislature has seen it fit to ensure that the legislation is provided for to ensure that people pay maintenance. So therefore we firstly have the Maintenance Act, which provides for us the procedures to be followed when it comes to maintenance. We also have the Constitution of South Africa in section 28 subsection 2, which says that the best interest of a child is of paramount importance. It simply means that we must always act in the best interest of children. As I indicated, we already made reference also to the Maintenance Act, but we also have the Children's Act, which specifically states that both parents have a duty to maintain children, and that the failure to do so is a criminal offence. We also have the Domestic Violence Act, which part of domestic violence is economic abuse. So the failure to pay maintenance is economic abuse and therefore fall within the Domestic Violence Act. We also have the Reciprocal Enforcement of Maintenance Act, which refers to cases where one party is residing in another country, which is called a proclaimed country or a territory. This simply means that countries have an agreement with South Africa so that maintenance orders granted in one country can be enforced in another country. This process involves the services of documents between countries through diplomatic channels. So, if we know now what is maintenance, then the question is, who is liable to pay maintenance? There are three requirements. A duty to support is, as indicated, based on three requirements. The first one is there must be a relationship between the parties that has a legal duty. There must be a need to be supported, and a person who is required to pay maintenance must have the means to pay maintenance. Those are the three requirements. So the next question will be then, who has a legal duty? Both parents have a duty to support their children. Both parents must support according to their respective needs. This includes adoptive children, also customary adoptions. Then there is a duty of grandparents towards their grandchildren. This is not an automatic duty. The rule is it will only come into operation once it has been found that the parents are unable to pay for maintenance. Then the grandparents can be joined in the inquiry. Also, brothers and sisters and half-brothers and half-sisters has a reciprocal duty to pay maintenance. Of course, this is not extended to aunts, uncles, nephews, and nieces. Spouses also has a duty to support. Obviously, if one looks at spouses, one must look at the Divorce Act, and I'm sure that Advocate Makata will deal with this aspect more in depth with regards to what happens when spouses want or require maintenance from another spouse after divorce. What I can say now is that such maintenance orders are usually subject to judicial discretion, and the court will take certain aspects in consideration before deciding into granting spousal maintenance. Then lastly, we often get the question or this assumption that maintenance is only paid until a child is 18 years of age. So the question is, how long are you responsible to pay for maintenance? And does that duty to support cease when your child turns 18 years of age? And I'm also sure that Advocate Makata will deal with this aspect. But in short, no, it does not. There's not a specific age where that duty ceases. One has to look at, is there still a need to support this child? And usually it is when the child becomes self-supporting. So obviously each case will have to be decided on its own merits, and one will have to look at the needs of the child that still needs when you get divorced. What is the process for spouses and children when it comes to maintenance? Thank you very much, and I will hand over to my colleague, Advocate Makata. Thank you.
Thank you very much, Krista. As earlier indicated, my name is Mokadi Makata. I'm the Senior Provincial Maintenance Prosecutor for Mpumalanga Province. And may I take this opportunity to recognize the presence online of our special director and her deputies in all provinces, and to all my colleagues, the senior maintenance prosecutors from all 9 provinces within the country. And as it was indicated from the program by Advocate Ngula, that I'll be doing divorce and customary marriages. Allow me to say that when we deal with maintenance in divorce and in customaries, it is one way, if one has to look at the National Strategic Plan, that is Pillar 5, it is consistent with maintenance where it talks about economic power. Now, how is economic power so relevant in maintenance? Pillar 5 on economic power says we need to strengthen the maintenance and other related systems and how to address the economic vulnerability of women. Now, I saw it fit and necessary, in as much as we are in 16 days of no violence to women and children, that I should cover in our topics spousal maintenance emanating from divorce, spousal maintenance emanating from recognition of customary marriages in terms of Act 120 of 1998. Let me start with spousal maintenance from divorce. In most cases, you will find that the women who are the applicants or the respondents in divorce matters, in most cases, they have been left high and dry during the separation or during the divorce when it's at the preliminary stage, having no funds can take care of themselves, nor the children, or the legal costs. Now, the Divorce Act, in terms of Rule 43, allows that women who are in need of financial relief can apply to the High Court for a Rule 43 application, that is for financial relief order during the process of the divorce. Now, once that agreement has been done, let's assume that the application is granted at the High Court as Rule 43, said and done. Or you find that there is a settlement agreement, but yet the divorce is not yet been finalized and that agreement has not been enforced. Because remember, a settlement agreement becomes only effective and enforceable once it has been made an order of court by the judges during the divorce proceedings. Then that is when it becomes binding. Now, where there is an agreement and with the divorce still pending, not yet being enforced, the complainant or the woman seeking financial relief, she can also at the same time with that agreement approach court and said, we have agreed with this amount of money as per our agreement in the divorce settlement. Then we are in a position to can issue the subpoena to the respondent to come to the maintenance court where we will register a file and then converse with the respondent that as per agreement of their divorce, they have agreed on this specific amount, which it will be made an order of court at the maintenance court level. And then once we have done so, then that maintenance order from the magistrate or our maintenance court will form part of the divorce processes. And we know that when the divorce is nearing the end or the decree will be granted, maintenance will cease to operate. So we are, as the maintenance court, we are vested with those powers by the Maintenance Act to can do maintenance where the agreement is there but not yet being enforceable. But then once we are being approached at the magistrate level, at the court, at the maintenance section, we are able to can make that order as per agreement from the divorce agreement. Now, Rule 43, a person can ask that you must understand, Rule 43, when it's been granted at the High Court, the judges have got no time to go through all the expenses, the earning capacities, and how one distribute his earnings, and then how much is left for distribution for survival of that person. The judges will base their judgment on what is being placed before them. And then you will find an instance where the respondent, after the Rule 43 has been granted, saying that he is unable to can keep up with the payments of maintenance. So in such an instance, what is the remedy if Rule 43 cannot be complied with, but partially can be? The respondent can approach court, that is the maintenance court, and request for variation. Is it possible? Yes, it is possible to vary the Rule 43 High Court order at the maintenance court in terms of Rule 43 sub Rule 2 of the Superior Court Act. The only reason or a reasonable good cause to ensure that there is variation that can take place, it is the duty of the person who applies, that is the respondent, to take court into confidence that he's got financial challenges, that his financial statuses are downscaling. So it is his duty to take the court into confidence that my finances are downscaling. Then, once the determination has been done through the investigation processes where he will bear everything before court to say, here I am, take a look at my expenses, this is what has been ordered for me to pay and I cannot afford this. That's how one has to take courts into confidence, to bear all your expenses open to the court to see. Then once the court is satisfied after seeing all the expenses, all the earning capacities vis-a-vis the Rule 43 order has been granted, then the court will be in a position to can vary that Rule 43 order. The only thing that is impossible to can be done with Rule 43 application is that Rule 43, you cannot appeal Rule 43 because it is an interlocutory application. So you cannot take it on appeal. But variation, yes, we can vary Rule 43. The next question is, let's assume the respondent in Rule 43 has not been, he's got arrears, and the order is been, the decree has been granted, the prayers have been granted as wished, as per their summonses. What do we do? The applicant can approach the maintenance court and say there are arrears in this maintenance Rule 43. And at magistrate level, at the maintenance court, remember that maintenance arrears are there for a period of 30 years because it's a debt judgment. So as long as the TS hasn't yet expired, arrears are recoverable. So even in Rule 43, even though the decree has been granted, but there are arrears, applicant can approach the magistrate court, maintenance court, for the recovery of the arrears. Then the arrears can be attached from the respondent salary or can be attached from his bank account, or a warrant of execution against property can be issued as one way to recover the arrears in Rule 43. So that is how, in terms of Pillar 5, we talk about addressing the economic vulnerability of women. Allow me to move to the recognition of customary marriages as per Act 120 of 1998. Women who are in marriages where they are being customarily married sometimes find themselves in a predicament of not knowing what to do when it comes to lack of financial support from their husbands. If one has to look into the Recognition of Customary Marriages Act, Section 3 thereof, it says the parties to the marriage must all be above the age of 18 years. And secondly, they must both have consented to be married in terms of customary law. And thirdly, there must be an offer and acceptance among the two families. That is, from the prospective husband to the prospective wife. The prospective husband's family will make an offer to the prospective wife's family. Then the wife's family will accept the offer that is being given by the prospective husband's family. And Section 3B says, once all the requirements have been met and that marriage been celebrated in accordance with the customary marriage is to be recognized as to be a marriage. That concludes that to be a marriage. And we know that when there is a consensus among the two families, that is of the prospective wife and the prospective husband, there is that note, an agreement that forms part of the meeting of minds of the two families, where there will be witnesses from the prospective wife's family and witnesses from the prospective husband family, and the witnesses who can attest that indeed these marriages did took place, and there was consensus amongst the two families to can agree that we have now concluded a marriage among the two families. So, under the circumstances, having said that, and then having exhausted all the processes to recognize that marriage, then if there is no economic support from the husband, from the customary marriage, then the applicant, who happens to be in most cases women, can approach the maintenance court for an application for spousal maintenance. And then in court, evidence will be led from the complainant and also from the respondent. How? The complainant will be there to testify that yes, marriage did take place if the respondent contests that there has never been such a marriage. The complainant will take a witness stand, testify, and then she will produce that piece of paper or the agreement that was reduced in writing. And then witnesses who were there from her family side will also be called to attest that yes, indeed marriage did take place. And based on the totality of the evidence, then the spousal maintenance will be granted from the customary marriage as a result of the recognition of the Customary Marriages Act. So, also in customary marriage, women must know that that is how we can address their economic vulnerability in terms of Pillar 5 of our National Strategic Plan. That will be that on spousal maintenance, on divorce, and on recognition of customary marriages. Next one.
Formal and informal inquiries.
Thank you. Maintenance. Like as said by Advocate Krista, that when two elephants fight, is the grass that suffers. It is true. The grass that suffers literally are children in relationships. And one has to understand, why do we have what we call family courts in the establishment? One needs to understand that we are having family courts because family courts represents the vulnerable groups within the society. The vulnerable groups happens to be women and children. Vulnerable groups are people who don't have resources to can push, to can adjudicate, to can express their frustrations, but solely relies on the courts to can facilitate their frustrations so that they should get answers to their frustrations. So one needs to know that also family courts are there to address the imbalances that are being caused by breakups in love relationships and marriage relationships. And in most cases where there are breakups in relationships, the person who bears the cost or who feels the burden of separation are women. And it becomes a double standards or secondary victimizations to her if she is employed and she's got children to take care of with no one to be a child mender for her. It means she must first make sure that she prepares for the children before she can look unto herself before going to work. And even it's worse that you find it's an 8 to 9 or 8 to 4 employment, and then children are coming back from school around 1 o'clock, and there's no one to take care of them. You wonder, how is this woman coping? So family courts are there to address such imbalances because we are dealing with vulnerable groups within our society. And one must understand that when you deal with the vulnerable groups, these are people who solely depends on us, the state employees, to always give a hearing to them. Because there is nothing that heals a person whose feelings are wounded than giving an ear. A person whose feelings are impaired feels very much healed when you give that person a hearing. And the mere fact that you have time to listen to that person's frustration. The moment you listen, it is all about your attitude. It defines your attitude towards that person. And having to give an ear is not a skill. It defines one's attitude. So it is always very much important when they say, from the Batupili principles, courtesy. Courtesy goes hand in hand with attitude as to how you treat that person. Like I always say, in maintenance, you don't attach your personal emotions. It's all about cognitive empathy approach. Walk the walk of a person before you. Understand the plight of that person. It also is to yourself as an official. Lose yourself to understand this person. Now, how does one apply for maintenance? Maintenance to be applied, one has to have the birth certificates of the children, marriage certificate if married, proof of residence where you reside, the address where the respondent stays or works, and your 3 months bank statement. Why 3 months bank statement? So that if an order is to be made, money should be paid into that corresponding bank account. Why do we have, are we in need of a proof of residence? A proof of residence, according to the maintenance, it determines jurisdiction. Because Maintenance Act says
According to the maintenance, it determines jurisdiction. Because maintenance
Okay.
depends.
So your proof of residence defines the jurisdiction for an application for maintenance, because it is a requirement that maintenance can be instituted in a place of residence, place of where the person works, where a child or the person whom to be supported resides with the person who applies for maintenance. That is the significant part that is played by the proof of residence to determine jurisdiction. The question is, what if I'm working here and the child are in another province where I'm coming from? The physical proximity of the children does not mean that you don't have jurisdiction. Because at the same time, for you being in another place, it is what we call domicilium of choice. You are there because of employment. And you have never relinquished your parental responsibilities for those children or for those children who are in another province and you are here in this province, but you are there because of work. And then you have not relinquished your parental responsibilities. You are the one who's taking care and maintaining those children. So those are the requirements that are needed. And when you get to court, you at the magistrate court for maintenance, you'll find the maintenance clerks there who happens to be our gatekeepers. And then you will give them those requirements as requested. And then once the file has been processed by the maintenance clerks upon checking all the requirements, then she will take that file to the maintenance officer. Why? That file has to be taken to the maintenance officer to consult with you as a complainant to check and go through your expenses and to check how do you account to the amount that you have applied to. You need to show to him in consultation that why you have made an application for 1,000 rands. It is because of this and that and that. What is it that I'm referring to? I'm referring to your expenses. You need to substantiate your expenses. One way of doing this is to make sure that we are keeping artificial expenses that can be claimed, which happens to be what are artificials. What I'm referring to when I talk about artificials, I'm talking about wants. If you talk about a want, it is something that you can live with or without. But a need, it is something that will always be there. For instance, having to get a bread. A bread is a need. But if you multiply policies, you've got 5 policies, same beneficiaries. That is not the need, it's a want. We can do away with those things. So that is actually what I'm referring to when we do consultation. We take a look into your artificial expenses, which happens to be your wants, which we have to do away with them, but we mainly focus on the needs. Once we have consulted with you as maintenance officers, we will check with the respondent. We will issue what we call Regulation 3 to the respondent, notifying him of your application that you have made against him for maintenance to this specific court. What is Regulation 3 or directives? In simple terms, it is what we call notice to show cause. Notice to show cause is where we are saying to you, we give you this date to come to court so that you should tell us, why can't we make this a final order? Come tell us about and show us your expenses, your earning capacities, how you distribute your money after you've been paid to service your debts, and then how much is available for distribution, and what is your take to what the applicant has applied for in terms of maintenance. And once we have issued Regulation 3, and then the respondent comes, and then we come together on one table, and then we navigate through all the expenses of the applicant and that of the respondent. And then if both parties on similar day agrees that no, it's fine, the amount that's requested, I'm able to can pay it, then we will make that agreement, we'll reduce it in writing to be binding. We'll take the parties to the magistrate, and it will be endorsed by the magistrate to enforce it to be an order of court. That is in terms of Section 17. That is consent. The parties have consented. Now, what if we are in consultation where we came up with a consent? That is where we have addressed what we call informal maintenance proceedings. Now, where we found that we have tried to exhaust, understand the purpose of us as maintenance officers there, it is not to inform the complainants or to school the complainants. We are there to mediate. So once we have mediated and there's agreement, that's what we call consent. That will be reduced in writing, and we'll take it to the magistrate to be sent and enforced as to be a court order. And as maintenance officers, we are not allowed, and it is not our duty to force the applicants to accept what is not reasonable to them. It is not our duty. Where we are having a informal consultation with the parties and we cannot reach consensus, then we have to take this matter to court for Section 10. What is Section 10? Section 10, it means that is where there will be a magistrate to adjudicate all the proceedings. That is the applicant and the respondent and the maintenance officers. What is the role of us, maintenance officers, and the judiciary, that is the magistrate, in the formal proceedings? In the formal proceedings, the magistrate and the maintenance officer don't play a passive role in the proceedings. They must play an active role. They must play an active role. Now we are in court. How do the formal proceedings unfold in court, and how do we play active role as maintenance officers when we are in court with the judiciary? The complainant will be led by the maintenance officer in terms of expenses. Thereafter, what we call examination in chief. Thereafter, cross-examination will emanate from the respondent. He will ask questions relevant to what was said in terms of applicant expenses and her application of an amount in request. The magistrate will assist the respondent in cross-examination, so that, because the respondent is a layman and the magistrate, it's his duty to bring on board relevant information which the respondent was not aware of. One can ask a question to say, why does magistrate have to ask questions? Maintenance is not like a criminal court. Maintenance court is a sui generis court. Magistrate, that's how they play an active role, because maintenance is a sui generis court. He must ensure everyone in the proceedings must play an active role for a justifiable conclusion in the matter. So once the magistrate has assisted the respondent in cross-examination, then he will close he will say it's enough, this is all what I had on cross-examination, and then that will be that. Then what happens next is that when it is the respondent's turn to give court, or what we call examination in chief, the evidence, the maintenance officer will also lead the respondent in presenting his case to the magistrate. Then on cross-examination, the magistrate must also assist the applicant to bring relevant questions who can be asked to the respondent relating to the expenses or the earning capacities of his. And then when there is no more questions emanating from the applicant, that will be that. Even when the respondent will be cross-examined, the applicant will also cross-examine as well, and should also be assisted. Once all the evidence has been laid before court, when it comes to issue of what is reasonable, that can be paid by the respondent from the evidence that was laid. The maintenance officer will also be given a chance by the magistrate to address him as to what are his arguments relating to the applications before court from the evidence that was led from both parties. Then after the argument has been submitted by the maintenance officer, the maintenance magistrate will make an order from the evidence that has been led and the arguments that have been presented. And even on arguments, not only the maintenance officer will be given a chance, also the respondent will be given a chance to give his arguments, and then also the applicant will be given a chance to forward her arguments. Then upon closing of everything, the magistrate will be in a position to make a justifiable conclusion from the submissions by the applicant, by the respondent, and the maintenance officer. Then the order in terms of Section 16 is being granted. Then, what is it that is so important that is played by Section 10 in the maintenance proceedings that talks to us as maintenance officers? Section 10 says, postponements must be avoided as much as possible. Maintenance matters must be finalized as quick as possible. With the Department of Justice, it's turnaround time of 90 days. And I can say that when I do maintenance training, I do tell our prosecutors about the 90 days turnaround time. And then we should try to embark on that as one way of expediting maintenance matters. And it is Section 10 that says, any party who is not an interested party in the matter must be excused in the proceedings. Because maintenance, it is family matters, it is being dealt with in camera. So, the person who's been brought before court for maintenance cannot bring his girlfriend or his new wife into the proceedings. That person is not allowed, because we are talking family matters here. So that person, it is Section 10 that guides us. And it is Section 10 that also talks about the representatives. If both parties want to be legally represented, it is Section 10 in the Maintenance Act that allows us, or allows both parties to can have their legal representatives. And allow me to say, even when the parties in Section 10 proceedings are legally represented, the role of maintenance officer is not passive still. The maintenance officer must always have ears on the ground to bring to the forth questions seeking clarities which were not asked by the defense or by the legal reps for both parties, either on examination in chief or in cross-examination. Maintenance officer will always play a role by asking relevant and bringing relevant information which was not brought and being asked by attorneys. That is on examination in chief and in cross-examination. And it is section 10, again, that talks about interim orders according to the Amendment Act of the Maintenance Act. Section 10 says, where evidence is being laid and then postponement it is imminent, interim order may be granted. And it goes further to say, where no evidence is being laid, but postponement it is imminent, interim order can be granted. So section 10 of the Maintenance Act, it is the cornerstone. It is the best KPI in the Maintenance Act to ensure that we addresses the vulnerability economically of women, and as one way of strengthening child maintenance, as it is also listed in Pillar 5 of our National Strategic Plan. We are in par with maintenance with Pillar 5. And then we go to what we call Section 18, order by default. Allow me to indicate, before I go to that, allow me to say, Section 16, it is one of the orders that are appealable. But Section 17, order by consent, we cannot appeal. Section 18 is one of the orders that are there in the Maintenance Act. In terms of Section 18, you found that the respondent has been served with the summons to can appear before court, or he's been warned to be available on the next court appearance, and he was duly warned. He does not pitch up for court appearance where he was warned. He does not come to court when he was served with the subpoenas. How do we go about? When the respondent has been served with a subpoena, we need to check what we call proper service. What constitutes proper service? The law requires that a person must be served 14 days before the hearing of the matter. Why? We give that person can be able to consult if he wants an attorney or to prepare him or herself for court. Comes 14 days period, then we are within the ambit of the law to constitute what we call proper service. And also, it must be signed either by the respondent himself, where he stays, where he works, any person above the age of 18, the supervisor at the place of employment, or can be affixed at the main door. And there must be a date when that person was served. And it must be signed by the person who served, either the maintenance officer, the maintenance investigator, the police officer, or the sheriff. Once it's been signed by the person who served it, there's a date, and either it's been served personally or any other person as long as above the age of 18, and it is within or prior 14 days before the hearing. That is proper service. Then we can present it to court to say, confidently so said, Your Worship, the respondent was served, and Mr. Mangung failed to appear before court, Your Worship, and then he's been served properly. The court will look into those things that is being served, whether either personally or any person above the age of 18, where he stays or where he resides or where he is employed. And then if there's a date, a month, and a year, and then it was duly signed by the person who served it, then the court will grant us the order. Then when we go into order by default, remember the respondent is not before court. So the court will make or grant an order based on the evidence that will be led by the applicant in assistance by the maintenance officer, which means it will be an evidence of a single witness that will drive the court or influence the court to grant an order. And once that order has been served, the order has been granted, then if the respondent it can be served, it might be served to the place of employment of the respondent so that money should be deducted from his salary. Then the respondent, after he has been, his employer has been served with the order by default, then he can apply for variation or what we call rescission in civil. The law requires that he must make an application within 20 days period. Then the respondent will make his application to vary that order by default or to rescind that order by default. Then that is when he will be given a chance to bring in his expenses, salary advices, and his bank 3 months bank statement as well, to can see whether indeed, in all fairness, will he be able to carry on paying what was ordered in default. And if not, the variation will be influenced by the expenses of the respondent, his earning capacities, and how he distributes his money upon being paid. Then the court will vary that order. That was in terms of Section 18. So it is possible that Section 18, it can be varied. So remember that those are the 3 orders that are also available in the Maintenance Act. That is in terms of Section 16, Section 7, Section 16, where we are with the magistrate and the magistrate makes a court order. We have consent, Section 70, where we sit with the parties and then they agreed among themselves to the amount. And then we do Section 18, order by default, where the respondent is not before court. But then unilaterally, the court will take decisions based on a single witness evidence. Now, the argument will come. Men will always say to court, the complainant is lying with her expenses. Remember that always we do investigations, and once maintenance officer is satisfied, he will institute the proceedings in a relevant court, because investigations are being conducted and were conducted. And one must not forget that according to law of evidence, a single witness evidence, the court can decide. So in maintenance, we are dealing with a single witness who happens to be the complainant, the mother who happens to be taking care of the children and maintaining these children. And as a single witness, she knows better than any other person who can come and attest. So the single witness evidence, it is applicable in terms of law of evidence in the Maintenance Act. Now, we are having these three orders. And in these three orders of section 16, 17, and 18, that's what we call variation. The question is, can the original order be increased after a short period has lapsed since the granting of that order? The answer is yes. Why? So possible. The order has got only 3 months being granted or 4 months being granted, now there is an increase. How is it so possible? Maintenance is all about a good cause. You need to indicate the good cause. And if one has to, one of the best cases that have been said is that of Watson versus Watson. The case of Watson versus Watson says that when the best interest of a child necessitates a change, variation should proceed. Now, how does the best interest of a child on good cause necessitate a change? Applicant, you are being granted a maintenance order of 1,000 rand. All what you need to do to take the court into confidence is to say to court, look, from this 1,000 rand, I'm paying school fees, buy electricity, buy food for the children, and that 1,000 rand is exhausted. Show us why you want more money. You simply say, apart from what I have said, there are no provisions for clothes. Winter and summer. There is no provision for school uniform, stationery. That necessitates a change, as per Watson versus Watson case. And once you have taken the cause into confidence, the confidence that you take the court into, it is a sign that necessitates a change to say, no, this woman indeed she is in need of this. So, don't stay in your corners and think that variation is not possible. Krista, variation is possible. Anytime.
Thank you, Andres. I think that is very important information for our public out there to know, because often I think we have seen, both of us, that often in maintenance for years, sometimes the whole school period that the children go to school, that not once do they actually come to court to apply for variation, simply because people do not know this information.
Mm-hmm. No.
So, Advocate, if I can ask you then, now we have an order, either by default or by court order or by agreement, but what happens if somebody does not pay?
Okay.
What remedies? Are there remedies available? And if so, what are those remedies?
Okay, Krista. Thank you. That's another topic that we will be jumping into, Krista. I'll be jumping into. Like I have exhausted all the court orders and the variation, the possibilities of variations. And not only to say that Krista variation it necessitates changes necessitates for variations. There's this judgment from Gravenstein case where they said this woman was constantly applying for variation, and then when she was asked, then this matter was taken to High Court, and it was found by the judges to say what she actually was doing in those constant applications, she was promoting the best interest of the child. So when you look into Gravenstein and the Watson case, the Watson case says the best interest of a child necessitates variation. When you look at Gravenstein case, it says when she constantly applies for variation, she's promoting. So it is very much important to promote the children's rights. And then it is so in line with Article 3 of the United Nations Convention on Rights of Children. Article 3, it says, in any matter concerning a child, the right either by a private institution or a public institution or a court of law, the children's rights takes paramount approach. So these two cases, when you align them with the United Nations Convention's Rights of Children and Pillar 5 of National Strategic Plan, we are there to uphold, promote, and protect the rights of the child contained in the constitutions. And not only Section 28 in the Constitution, but for maintenance for the child, you look at Section 10, Section 11, Section 27, 28, and 29. Thank you so much, Krista. And with the same breath, let's go to where there is no compliance, where the order has been granted. Complainant, once you are being offered, there is a court order that has been granted either by Section 16, Section 17, and Section 18. Yeah, you have the respondent, and then the respondent is not in compliance. Are there any remedies? Yes, there are remedies that are available to can ensure that we recover what is necessary for the child. What are those processes? 10 days. Always complainants must ensure that once 10 days period has lapsed without compliance with the court order, you must approach the maintenance court to complain that Mr. Mangum has never complied with the order, even though the court has ordered him to pay. How do you do that? You go to the maintenance court. You'll find the maintenance clerk. You will complete a form for failure to comply with maintenance. And then you will also outline the periods not being complied with in your affidavit, as it is required by the Act. And then obviously there will be a court order to refer to. Why do we need an affidavit in your file? Your affidavit is one way of presenting your story in your absence. When you are not before us, your affidavit talks to us. It represents you. Your affidavit entails the periods where the respondent has never been in compliance. And then we will look those months with the corresponding bank statement that we have brought as a proof that these months, as per my affidavit, Mr. Mangu never paid his maintenance. So keep in mind and be aware that 10 days period is reasonable, and it is a prescribed period to lay a complaint for non-compliance with the court order. What are the remedies that are available to can recover those arrears? We are having order by default, emolument attachment, warrant of execution against property, and attachment of a debt. Those are 3 remedies. How do we make them feasible? This is how we do them feasible. All 3 processes, in terms of application, the approach is the same. Affidavit, bank statement, court order should be there. The approach is the same. After the lapse of 10 days with no compliance. Now, let's start with emolument attachment. Emolument attachment is where we take the money from the respondents or the fathers, the person against whom an order was made, from the employer. To ensure that there's feasibility to that, the Act requires us that we need to, one must understand that emolument attachment is a third person. Is a third person. That is, we are talking about the employer. So to ensure that there is compliance and feasibility, we need to inquire from the employer. Inquire what? We need to establish with the employer that, is it true that the respondent, Mr. Mangung, is still employed with your department? Is he still earning salary? And if it's yes, we will require the employer to forward us proof of earnings of Mr. Mangung for at least 3 months. Because remember, Section 7 of the Maintenance Act says we must investigate the complaint. So there's a complaint for non-compliance, and then we need to investigate. How do we investigate? For the feasibility of this enforcement of emolument attachment, let us consult, investigate with the employer whether Mr. Mangung is still employed with the department and is still earning. Once he's still earning, let the employer give us 3 salary advices of Mr. Mangung. Then we're in compliance with the investigations. Then, once we are in possession of the salary advices, then we are able to see that the amount that we can attach for the recovery of these monies is feasible. Even when we make our presentation to the court, we will inform the magistrate to say we are also in possession of Mr. Mangung salary advices from the employer, as the employer was conscientized by the maintenance investigator that we are in need of Mr. Mangung salary advices because he has failed to pay maintenance. And if maintenance officer investigator is the one who has done the investigations relating to sourcing the salary advices, he must attach his investigation statement because he was acting on instructions. Seasoned prosecutors know that if you want to ensure that you prosecute successfully, all the evidence is there, you give investigating officer instructions as per SAP 5. And then after he has gone through the SAP 5 instructions of a prosecutor, he will comply with the instructions and do his investigation statement on Part A of the docket. So that if we are in need of this investigating officer for any other evidence in court, through his investigation statement, we are able to say, you have made your statement about this investigation, then you are a witness, you are needed. So it is very important that in maintenance investigators, on every investigation that they do, there must be an investigation statement, so that when we go to court, criminally as well, once we have made a disclosure, they are part of the proceedings, not to be so-called surprise witnesses. So, once we have made a submission with all supporting documents for emolument attachment to the magistrate will grant that order. The magistrate may not grant the order. Section 16 also guides us to say where there is an order and then you apply for variation, substitution, the court may make an order or make no order, depending on the circumstances that prevails before court. So we are all guided by the Maintenance Act. Actually, we are all guided by the legislature. So everything that maintenance officer does in court, we are not thumbsucking these things. I know that there's pressure always. There are expectations always from the complainants. But maintenance officers and maintenance prosecutors, we are being guided by the legislature. And it is my wish that all people who are applying for maintenance can understand that we are all, as the NPA and as Department of Justice, to confine ourselves within the ambits of the legislature. And at no material terms will deviate from what is expected of us. Because it says we will prosecute without fear, favor, or prejudice. Now, once an emolument attachment has been granted, the maintenance officer must submit it to the employer to deduct those monies. It will be our arrears and our monthly maintenance contribution, direct from Mr. Mankun's salary. And then we know that economically we have addressed the vulnerability of the complainant, and then we have strengthened the child maintenance. And by simply deducting that money, it is a system that we have also strengthened according to Pillar 5 of our National Strategic Plan, and as it is expected of us in terms of the Maintenance Act. You come to a second remedy, which happens to be an attachment of a debt. You find that there are arrears. Complainant is here. Mr. Mangung is one person who is having not a full-time job. And then there are arrears. And then when we look, after we have done investigation as is expected of us, we found that Mr. Mangung has got money into his bank account. And then we'll request from the bank to give us a printout as to how much is available in Mr. Mangung's bank account. And through expert application, we'll approach court to say, Your Worship, together with the application of the applicant, either the applicant will do that viva voce or will read from the affidavit. That's why the affidavit is so important. If I decide not to lead my witness, I will rather read from what it is there. Then we will ask the court to can attach the bank account of Mr. Mangung so that we should recover what is owed to the child, not the complainant, who happens to be the mother, but we are here for the child. We are promoting and protecting the rights of this child in question. That is how we attach a debt. And the last one is a warrant of execution against property. A warrant of execution against property is one of those remedies that are very challenging. Because when we do emolument attachment and when we do attachment of a debt, it's between us. On emolument is between us and the employer. Between us on the debt is between us and the bank. Now, with emolument attachment, you rely solely on the services of a sheriff, which is a cost on its own. Like I said, all these three remedies, the approach is the same, but they only differ in terms of application processes of each. With attachment of properties, we will have to check, that is, we do investigation to check whether there are any other properties registered, either immovable properties registered in the name of the respondent, any investments in the name of the respondent. We check as well the immovables. Are there any houses that have been registered in his name? Once we have done all the investigations in terms of immovables and movables properties registered in the name of the respondent, the investigator will give us the return, the report as to what his findings are. And what we will do, we will communicate with the sheriff with regard to properties identified. Because remember, maintenance, we are not talking about the actual, only the actual earning. We are also looking at capital. We are looking also at capital. Those properties are capital. So, once we have done that, we will forward our maintenance investigators' report and findings as to which properties can be attached. And we will prepare that and send it to the sheriff, what we call an inventory. We prepare an inventory. We send it to the sheriffs. Upon acknowledgement of receipt by the sheriffs, our inventory, then our sheriff will have to go to the respondent's place to can attach. And in most cases, we'll request in our inventory to attach and remove. And then one must take cognizance of the fact that if one is to attach and remove, you remove, then it means there are removable costs. The properties needs to be removed and there are costs involved there, transportation costs. Then the properties will be removed, will be attached, removed, and then where they will be stored, it's cost. We call them storage costs. Once the sheriff has attached and removed, he will send us the inventory to our satisfaction that now, as instructed, I have attached and removed the said properties as well outlined. There is my inventory. Then the sheriff must ensure that he prepares notices for advertisement. All these advertisements must be placed on the necessary relevant courts, notice boards, and newspapers for reference. And once the date has been set for auctioning, the sale will proceed. Now here is a challenge. In maintenance, you might find that yes, we can successfully attach the properties, né? And then we successfully go and sell, only to find on the last lap that actually all the proceeds of sale have not recovered or has not augmented storage cost, removable cost of the sheriff. The proceeds of the sale falls short We are even unable to can recover the area maintenance monies that we are expecting. So this process is disadvantageous. But I can tell you, and I can rest assure you, this is one process where we have made submissions. We hope that we will remedy this thing, because that is where what we call security costs are needed by the sheriffs. Why do we have to pay security costs? Security cost is to say, I have incurred cost to remove your properties. I have incurred cost to store your properties. Cost for sale advertisements. And the sale proceeds were not so sufficient to can recover the arrears, to have a surplus, to pay over for the arrears, and to cover my cost. So where does the sheriff recover his costs? From security cost that was paid. That's where the sheriff recovers theirs. So this is one of the challenging remedies, and a remedy which I believe that a person who is vulnerable as the complainant, a person who is seeking help from the court, has to be burdened with the cost of all these processes. But I hope that our requests in addressing and diluting the process to can accommodate and serve the purpose of maintenance will be achieved, and then we are expecting that very soon we'll be hearing the answers. So yes, those are the remedies that are available. Now, what is the position of the respondent if these three remedies are being granted and he feels that, no man, I was never given a chance to say my side of the story. I only see emolument attachment, my bank account has been attached, and then my properties have been sold. Is there a remedy for the respondent under the circumstances? Yes, there is one. There is one. The respondent has liberty to can challenge warrant of execution against property, attachment of a debt, and emolument attachment. And also the employer can challenge that based on feasibility of attachment, the emolument. So the respondent will make his application, and then the application will be served to the person in whose favor the remedy was granted to, notifying her that the respondent is challenged remedy that has been enforced. Now, we are now moving from civil remedies. We go to criminal. Section 3. Let me add this. Let me explain on criminal proceedings. I'll try. Sure. On we do section 31. We do section 31, that is criminal proceedings. Criminal proceedings are when all civil remedies are being exhausted by the maintenance officer. And then how do we ensure that the matter is ready? Prosecution is a last resource. We need to check the following for us when we go on prosecution. That civil remedies were exhausted. And then we have the statement of maintenance investigator as to his investigation report to civil remedies. And the statement of maintenance officer that I have given instructions to the maintenance officer to do the following. That is the investigations on remedies. And then the maintenance officer and the maintenance investigator must have their statements attached in the file. Why is it so important? It is so important because now it is a criminal matter. And once it goes to criminal matter, you will need witnesses. And then the only statement that will be contained in there will be that of the applicant, who happens to be our client. And then, to prove that everything, all necessary measures were taken to enforce the recovery with no success, it will be purely based on the investigations that were done by the investigator. And the investigator must attach his statement. And the maintenance officer must also make a statement to say, I'm the one who gave the instructions to the maintenance office investigator after I received a complaint that such investigations be done. And such statement must also be attached. Because when you go on trial, you need to lead evidence and you must prove your chain. You must prove your chain of evidence. And how do you prove your chain of evidence? You have your complainant as a complainant, and then you have a maintenance officer who received the complaint, and then the maintenance officer who issued instructions to the maintenance investigator to do the investigations. So it is very much important that our chain of evidence must be chronological to ensure successful prosecution. And when we proceed with Section 31, the only defense in failure to pay is lack of means. That is the only defense. Lack of means is the only defense that the respondent can bring before as a defense. And then if there are any other investigations that needs to be done, as prosecution, we will never withdraw that case or strike it off the roll for the sake of investigations to be done. The law says we must do the investigations while the matter is still on the roll. So it is very much important that our complainants must understand that it is a lengthy process. It takes time, and then in as much as we are trying to push, they should also exercise patience to give us enough time to can ensure that we do what is right. I understand maintenance sometimes the processes can be frustrating, but once we can be able to ensure that we compound patience, we know that we are succeeding in what we are doing. So, I may indicate that it is possible that once the accused person has been found guilty of non-compliance with the court order, a prosecutor can apply that matter be referred for recovery of maintenance arrears with interest. He must make an application to court in a criminal trial. Because sometimes it is a challenge, but I must say to you, is that case of State versus Magagula. It's 2001. It is one of the best cases that is guiding us as prosecutors how to deal with the processes of the arrears of prosecution criminally so on Section 31. And the complainants must understand that in criminal proceedings, the respondent cannot be given direct imprisonment because the law says the very same person who's the accused, he is in need to maintain his children. So direct incarceration will never solve any mishap that occurred due to his failure. Now, what do you look at when you say it's a failure? You look at the guilty mind of the respondent. We just have to look whether he was employed. During his employment period, did he pay? If he did not pay, then that constitutes guilty mind. And then how do you determine guilty mind? The willingness of the respondent not to work. That he went to work drunk, he was expelled. That is a guilty mind because it can be summarized to be a way of frustrating the process of maintenance. Or the respondent absconded and he was expelled. It's a guilty mind. So that is an element that one needs to prove as required in State versus Mangalore. So anything that is not in relation as a defense, as a lack of means, it is something that will lead to the conversion of that matter. And when the matter is being converted criminally, it does not mean everything is done and buried. We are still going to recover the areas with interest. So that is a nutshell in terms of Section 31.
Okay. I think at Pipakhata, there was just one more topic that we needed to cover. Maybe if we can give you 5 minutes just to discuss future maintenance.
Yes.
5 minutes.
That was the last item. Thank you so much. Future maintenance. Yes, yes. One needs to understand, and it's my wish that we preach this thing and our clients, the complainants, can understand that in terms of Maintenance Act, we don't have a specific provision that deals with future maintenance. But future maintenance, it is one of decisions that emanated from decided cases that of Mali versus Beacon Suites, Maheo versus Zozo, solar maintenance matters. How do we claim future maintenance? Future maintenance, actually let's say, what is future maintenance? Future maintenance, it is a process of maintenance where we place the child in a position of maintaining, of being maintained as if the father is still employed. When the father is still employed, he will pay. So once he loses employment, we need to place that child in a position as if his father is still employed. And then how do we do that? We do future maintenance where there is a court order of maintenance. We can do future maintenance. And we also do future maintenance where there is a threat that the respondent, he won't be in a position to can keep up with his monthly maintenance payment. And when we attach these monies, and then they are not being kept in the applicant's bank account. No. All these monies, after they are being attached, they'll be kept either at the master's office to be accessed, or DOJ is developing Moja Pay. We keep them in what we call Moja Pay in the Department of Justice, where it will be paid on monthly basis. So on monthly basis, it will be an order to the master. It will be an order of court, the ID copy of the applicant, the ID copies of the minor children, and the bank statement where the money will be paid into. And our court order must specify as to how monies will be paid up until which period. But now, with the case of Z versus Z, where mothers can still continue to set maintenance proceedings for their children or claim maintenance on behalf of their children, they can still continue to receive child maintenance monies under the circumstances, as per Z versus Z case. And if there are any variations, that the parties should approach court for variation to update the court order at the masters or at Majape at the Department of Justice. And all these monies will be kept in the name of the respondent, not in the name of the applicant. In case the respondent dies, those monies will be moved to the estate, and the estate will be the one, the deceased estate will be the one to pay maintenance. If it happens that the child dies in the process, the monies will go back to the father because they are still in his name. And if it happens that this child gets employment, the monies will go back to the respondent because they are registered in his name. So, that is the importance of future maintenance for minor children. And like I said, where the estate is being registered, all these monies will be there, and then the estate will set aside monies to exonerate the estate to be indebted to the child maintenance. That will be an application for maintenance through the executor. And once the estate has been closed, that is after the expiry of 30 days inspection period, it has been closed and funds are being allocated, the claim that will be made for maintenance, it will be against the heirs, because already the estate has been lined up, monies are being paid, and then it's an application to prove undue enrichment. You need to show as the applicant that why I'm saying that money is, the heir was unduly enriched. You need to show why you say that person was unduly enriched. And so far, allow me to say thanks to everybody who participated in these things, and thank you so much for giving me this opportunity to say this on maintenance. I always say to the maintenance officers and the prosecutors for this province, even where I'm coming from, I always say to them, maintenance is one of those spheres of employment where you see no evil, you hear no evil. So I push with that concept that if I have to source maintenance from the grandfather, I see no evil by bringing him to court because I'm executing my duty. And then for him to tell me that I'm getting SASSA monies, can I contribute from there? I see no evil for him to contribute from the SASSA money. So I hope the world see no evil, I hear no evil. I thank you.
Thank you so much to our advocates. We have certainly received so much clarity when it comes to maintenance matters today. There were just a few things I would just like to highlight that were quite important. I think it was important that they highlighted for us the fact that when you deal with maintenance, you're not only dealing with the Maintenance Act, there are policy directives, there is the Constitution, there is the Children's Act, as well as also to just to remember the amendments that come with the divorce proceedings as well as with the customary marriages. We've also learned a lot about the inquiries, the different orders that can be made, the remedies that we can resort to, as well as what future maintenance is. We would like to extend our greatest appreciation both to Advocate Du Plessis and Advocate Makata. And due to time constraints at this stage, unfortunately, we cannot get to the question and answer session. This is what happens when you deal with experts. You ask one question and you just get a lot. It's been a lot to take in, but it's been very informative, and we believe that it will assist our prosecutors also in the execution of their duties and improving service delivery. However, for more information, or if you want to receive assistance with pending applications, please do go to the National Prosecuting Authority in South Africa on Facebook, or email communication@npa.gov.za. And with the words of the great Bill Richardson, who once said, "We cannot accomplish all that we need to do without working together," we have now reached the end of our webinar. Thank you to all participants at this stage.